You have 15 minutes, and you may begin when you're ready.
Thank you, Your Honor. May it please the Court, Attorney Nick Klemenko on behalf of Father Mr. Dallas DeLotte. Your Honors, there are three assignments of error before the Court this morning. The first being that the trial court committed reversible error in that it granted weight to Father's urine drug screen on April 29th, 2016. The second, that it was against the manifest weight of the evidence to find that it was in the best interest of the children to be placed in the permanent custody of Summit County Children's Services. And the third being that Father's attorney at the trial court level committed plain error when failing to object to State's Exhibit 3, which included Father's April 29th urine drug screen. I would like to address the first two issues in tandem and then spend time on the third issue, Father's plain error argument. To help us along the way, some preliminary facts will be needed. On March 30th, 2016, Father was released from an Oriana facility called TMRC. As a part of his post-release supervision from TMRC, he was required to submit to urine drug screens. After release from TMRC, all Father's case plan required him to do was to meet the basic needs of his children and to obtain housing and employment. His case plan at the time did not require him to submit to urine drug screens. On April 28th, as a part of his post-release supervision from TMRC, Father went to submit a urine drug screen, which came back as a refusal on April 28th, 2016. Caseworker Martin from Summit County Children's Services was asked about this refusal and about her concern with it. Her reply was, "That is why I had him, Mr. DeLotte, go back the next day." Based on this unilateral, unjournalized request, Mr. DeLotte did return the next day and submitted a positive urine drug screen for cocaine, which was used against him at the trial court level. It is apparent from the trial court that the April 29th urine drug screen was granted significant weight at the trial court. Throughout the case, the attorney for the GAL, the caseworker, and the state's attorney all referenced this case, and most notably, the trial court cited the April 29th urine drug screen in its decision to grant permanent custody to the state. Mr. DeLotte relies heavily on the revised code 2151.412 section F2, which outlines the implementation of case plans. This court in In Re SDM interpreted this statute to hold that a caseworker may not independently amend a case plan by merely telling a parent to complete extra tasks. Appellee's brief states and argues that the trial court did not commit any plain error by referencing the April 28th refusal. We concede to this argument. What we do not concede to is that the unilateral, unjournalized request of Mr. DeLotte to submit to a urine drug screen the very next day, giving Mr. DeLotte little to no time to seek legal advice, was used against him in the state's case in chief and was used against him in the trial court's decision.
Wasn't it the fact that he tested positive used against him? I mean, he did go the next day.
Correct, Your Honor.
But you're saying he shouldn't have been required to go the next day.
That is correct, Your
Well,
Honor.
how does that fit with the dissipation rate of contaminants in urine? You're going to be able to prolong the test until it's all gone?
Well, if he was required to go the next day by Summit County Children's Services, we are asking the court to adopt a bright line rule in stating that that request needs to be journalized and amended by the court to give Mr. DeLotte time to seek legal advice with regard to that.
But the caseworker didn't indicate to him that this was a requirement, right?
That's something that we're not too sure about from the record. All that we have from the record is that the statement about the caseworker's concern about the April 28th refusal, and that her reply to that was, "That is why I had him go back the next day." So Based on that, it looks like it's a unilateral, unjournalized request by the caseworker for him to go back the very next day. And there's nothing in the record stating that he had time to consult his attorney. All we know from the record is that that was a task required of him to do by Summit County Children's Services.
But wasn't there, and I can't remember right now, but there was something that was in the record that, that she had asked him to do it as a favor, to accommodate.
I'm not aware of that. After reading the trial court transcript from her testimony, the only two parts of that is that she asked him to go back the very next day, and on cross-examination, father's attorney did elicit testimony from her that he did it voluntarily. But there's only a couple of references to that. His attorney and the state's attorney really didn't get into the colloquy between the Children's Services caseworker and Mr. DeLotte.
I'm having trouble understanding how the outcome of that event, just because drug testing wasn't required by the case plan, was error. I mean, the use of the outcome of that event would be just the same as if I asked him to go walk across the street and get a bottle of water for me, and he didn't have to, but he did, and then he did something bad on the way across the street. I mean, I'm having trouble understanding why the outcome is relevant.
The appellee made that same argument in their brief, and they cited in rape then. In that case, they used that a probation officer's testimony about the mother in that case was admissible because, even though it wasn't on her case plan, it was a part of her probation, and this type of testimony that she was committing in probation violations was admissible. We concede to that, and that is the fact. That is why Brian Newhouse came to testify concerning the April 28th refusal, because that was part of his post-release control from TMRC. Again, what we don't concede, in Ray Bennett differs from this case in that TMRC did not require Mr. DeLotte to appear on April 29th, and his case plan did not require him to appear on April 29th. It's a unilateral, unjournalized request by the caseworker. When not looking at that fact, and when we go into the other facts, we find that father was consistent with his visits. We find that father had a bond with his children. We find that father obtained housing and employment. We find that prior to the April 28th refusal, that father's drug tests were clean. We find that the father's son wanted to return to his custody. We find that the daughter of father had mixed reviews about returning. She was afraid of father's previous neighborhood, but father was in a new neighborhood, and the caseworker testified that she had no problems with father's new neighborhood, and that her fear could be treated with counseling. So when we don't look at the unjournalized unilateral request to have father submit to this drug test, we argue that it would have been in the best interest of the children at the time to be returned to father.
I see in my notes that there's been an allegation apparently that father had tampered with the urine screens.
That's correct, Your Honor. April 28th, there was a refusal where he tampered. It came out on evidence that he tampered with a drug screen. I'm not asking the court that the trial court should not consider that testimony, because that was part of his TMRC post-release control.
Does that not, that doesn't help our decision, or are you claiming that the pure technicality on the original drug screen is dispositive in and of itself?
I am stating that the use of the April 29th drug screen is dispositive in and of itself, and that the trial court cited that in its decision, and it cited that which was not journalized, and it cited that which was was a unilateral request by Summit County Children's Services, and as such, that it's reversible, Your Honor. I'd like to move on to father's plain error argument.
You have about 5 minutes left.
Perfect. In Appleby's brief, they stated that father's submission to the urine drug screen was freely given, and that this was a waiver of his rights and not a forfeiture. And in so doing, the state argues the Ohio Supreme Court case, State versus Payne, but this case in State versus Payne is different, because in State versus Payne, the Ohio Supreme Court was confronted with a defendant whose counsel failed to object at a sentencing hearing where the defendant was sentenced to consecutive sentencing. In State versus Payne, the Supreme Court of Ohio stated that if a party fails to object or forfeits an objection in the trial court, the reviewing court may notice only plain errors affecting substantial rights of the defendant. In this case, prior to the submission of State's Exhibit 3, that which included father's April 29th urine drug screen, father's counsel failed to object, resulting in a forfeiture. This is not a waiver where a client is waiving his right to have a trial, and there was some colloquy between the bench and the accused, and the accused waives his rights. This is a forfeiture. Your Honors, Mr. DeLotte submits to the court that the error is plain. A legal rule exists in Revised Code 2151.412, Section F2, and this court has interpreted that rule, and as such, Summit County Children's Services has deviated by unilaterally requesting an unjournalized task of Mr. DeLotte to submit to a urine drug screen on April 29th. The error not to object was plain, in that it was obvious. Throughout the trial court, the transcript is peppered with references to this April 29th urine drug screen not being a part of Mr. DeLotte's case plan, and the error affected the substantial rights of Mr. DeLotte, and that it affected the outcome of the trial. And we know it affected the outcome of the trial because the court cited it in its decision. Furthermore, we would submit to the court that if this had not been referenced upon the decision, and the case would have been different. Your Honors, we ask that you consider these 3 assignments of error, and Father would respectfully request that a reversal of this case be made, and also a remand of it back to the trial court.
You still have about 2 minutes if you wish to use them.
I do not, Your Honor.
All right, thank you.
Thank you.
We will take the case under advisement.
Thank you.
Send you a copy of our opinion when it is issued. Have a good day.
Thank you.